In this case, the High Court considered when people involved in illegal activity can make claims in negligence. The story starts at the Customs House Hotel in the Heritage District of Maryborough in August 1984. Four young men had been drinking there all afternoon. This was well before responsible service of alcohol laws, and Preston had consumed as many as 40 scotches. The others were just as drunk. They decided to steal a car and go on a joyride from Maryborough to Gladstone, where two of them wanted to visit a friend, and then on to Rockhampton to commit some burglaries. They stole a car in Maryborough and took off. Preston went to sleep in the back seat. Shortly before midnight, while Preston was still asleep, the car, which was being driven by Gala, left the road just south of Gladstone and hit a tree. One passenger was killed outright and the others were badly injured. Preston sued Gala in negligence, claiming that Gala's negligent driving had caused his injuries. On the face of it, of course, it seems pretty clear that Gala's negligent driving did cause Preston's injuries. And yet at the same time, they were together in a car which they jointly stole. Can the court realistically say what duty of care is owed by one car thief to another, or by one drunken car thief to another? The court ultimately decided that Gala did not owe a duty of care to Preston in relation to the driving. The four judges who composed the majority said, "It is difficult to see how they can sustain a relationship of proximity which would generate a duty of care. The joint criminal activity involving the theft of the motor vehicle and its illegal use in the course of a spontaneously planned joyride or adventure gave rise to the only relevant relationship between the parties and constituted the whole context of the accident. That criminal activity was, of its nature, fraught with serious risks. The consumption of massive amounts of alcohol for many hours prior to the accident would have affected adversely the capacity of a driver. As a result, the position at criminal law was that if the injury arose from some conduct which was performed during a joint criminal enterprise, but which was really quite incidental to the criminal conduct, a person might still sue in negligence."